Even C, IPC, okay. So from Unit 2, we discussed the general exceptions, which is that even though elements of crime are being satisfied, there are certain situations wherein a person can escape the liability. Okay, apart from that, we have another concept called abatement. Now, if you remember, from Unit 1, we had something called as possible parties in a crime. Okay, like this principle, possible parties to a crime, wherein we discuss principle in first degree and principle in second degree. So when we discussed about first degree, we saw that the person who commits the act with his own hands directly being present there. When we talk about second degree, there we were including many other people. We were imposing criminal liability on many other people who might be assisted the criminal, or who might be uh, like abated the crime, who might be uh, like made the other person commit the crime in some way, maybe by supplying the materials, or by provoking the person, etc. Those people were considered liable under second degree, wherein liability was same only. It's like as if the person has committed the crime but through another. Okay, so one of those was abatement. Abatement was also included there. Okay, now what is abatement? It is provided under sections 107 to 120 of IPC. Okay, so section 107 to 120, chapter 5. Okay, so if you think that how to remember the sections, right? Like this, you can remember. Chapter 5, sections 107 to 120 makes provision relating to abatement. If you can somewhere one or two section, maybe you can remember in between, but like this, it would be easier. 107 to 120 talks about abatement, just chapter 5. So when we talk about abatement, it is derived from the word abet, which means to aid, to advance, to assist, to help, or to promote, as in to provide some assistance to another person so that the other person is in a position to do something. In the case of Sanju versus State of Madhya Pradesh, the Honorable Supreme Court defined abet as meaning to aid, to assist, or to give aid, to command, to procure, or to counsel, to countenance, to encourage, to set another one to commit a crime. Okay, so a lot of different situations might be there wherein a person is in some or the other way helping the other one commit a crime. So in such cases, we will say abetment to commit a crime. Another person is guilty or responsible for abetment to commit a crime. Okay, so chapter 5 deals with abatement. It basically means action of instigating, encouraging, or promoting person to commit an offense. Maybe another person is instigating the other one that why don't you do this? If I would have been in your position, I would have done like that. So it's nothing but instigating the other person, or maybe encouraging. Okay, another person that you should do this, you can do it like that, or it is promoting the crime. So in either of the ways, it is helping or assisting the other person to commit a crime. So when more than one person contributes to committing an offense, each person's involvement may vary. The variation may either be in the manner or degree to which the involvement is there. So if one person is committing the crime, he will only be involved in all the different stages and he will finally commit the crime. But there may be situations wherein more than one person is involved. And abatement is also one such situation wherein one person would provide aid and assistance, guidance, etc., and another one would commit the crime. For example, one person may procure a gun and hand it over to another person. This is nothing but providing aid. Who may shoot somebody with it? So, this is nothing but someone has committed the crime with his own hands. His liability would be the principal in first degree, but this person who procured the gun, his liability would be principal in second degree. He is liable or he is guilty of abetment. Okay, so section 107 of IPC mentions regarding what abatement is. It requires a person to abet the commission of an offense. This abatement may occur in any of the three methods. So there may be three ways of abating a person to commit a crime. First of all, instigating a person to do something, encouraging another person in a conspiracy to do that thing, and intentionally aiding a person to do that thing. So there are three ways of abetting a person to commit a crime. First one is instigation. So instigation means suggesting, encouraging, inciting a person to do or abstain from doing something. Even abstinence would also be considered. So whenever we talk about crime or wrongs in general, it would include both act as well as omissions. So instigation may be sufficient to actively encourage a person to commit a crime. It should not be mere advice or a simple suggestion. The instigator need not even possess mens rea. So without, he cannot say that for crime, mens rea or guilty mind is very much needed. I was not having any bad intention. I was not having any guilty mind. Even in such cases, the person can be held liable because it was on the basis of his instigation that the other one committed the crime. So instigation may generally happen by willful misrepresentation or willful concealment of material fact, etc. For example, a court directs Amit, a police officer, to arrest Raj under an arrest warrant. Bridges informs Amit that Chandan is Raj despite knowing that he is not. Under this misrepresentation, Amit ends up arresting Chandan instead of Raj. In this case, Brijen is guilty of abetting Amit in wrongfully apprehending Chandan because the person was the one who was assisting or who was giving false information or misrepresenting. As a result, the situation has taken place. So, this is nothing but instigating another person to commit something. Abatement may be by way of conspiracy as well. So, conspiracy means an agreement between two or more persons to commit an unlawful act. Merely intending to commit an offense is not sufficient for this purpose. So, when we talk about conspiracy, conspirators must actively agree and prepare themselves to commit that offense. Then only we would consider it as conspiracy. The act which the conspirators conspire to commit in itself is illegal and punishable. So conspiracy to commit a crime in itself is punishable whether they finally succeeded or not, or what happened. Irrespective of that, it is punishable. Okay, for example, in dowry death cases, the in laws of the victim are often guilty of abetment by conspiracy. They may do so by constantly taunting, torturing, or instigating the victim. Even suicides may take place in this manner through abetment by conspiracy. So, over here, we would talk about conspiracy because the person ultimately died because of the continuous situation that was arising. Okay, so it may be by way of instigating another person to actively encourage a person that you should do it, or I would have done in if I would have been in your case. Abetment by conspiracy. It's like an agreement between two or more persons to commit an unlawful act, or it may be abatement by aiding as well. So, third manner in which abatement may take place is by intentionally aiding the offender in committing that offense. So, this happens when abater facilitates the crime and helps in committing it. The intention to aid the offender is very important. So, it should not happen that by like a coincidence it just happened, but the person should knowingly help another person in committing a crime. For example, merely giving food or clothing to an alleged offender may not be punishable, but giving him food and clothing and shelter to help him hide from police or commit a crime is punishable. This is something we discussed in this principle of second degree also. Right? If someone knowing that this person has committed a crime, even after that helps him to escape from police or help him to escape from legal consequences. There, the other one would be liable under principle of second degree. Right? That knowingly he tried to help this person escape the punishment or the liability. Okay, so three things are there by instigating, by conspiracy, and by way of aiding the other person. Now, talking about punishment, abatement of certain offences is punishable under specific sections. There are some provisions wherein we need a special mention of abatement. Okay, for example, abatement of suicide is punishable under 306. However, when no specific provision exists, the abater will be punished with the same punishment which is prescribed for the particular offense. So, if one person is abating commission of maybe causing of grievous hurt, whatever is the punishment for grievous hurt, same would be applicable. So, like that, whatever punishment is given for the complete offense, that only would be provided for abatement as well. So 306 abatement of suicide. Definitely suicide is different and the one abating suicide is different, right? Because in suicide the person himself will decide to kill himself, but here somebody is abating the suicide, right? So here we have a different punishment for abatement. So if a person commits suicide, whoever abates the commission of such suicide will also be punished, right? So here punishment is different, it would be 10 years. But for suicide also there was a punishment which used to prevail, but that, so if you look for suicide, attempt to commit suicide was also punishable, like it is punishable under section 309. Okay, so it says that person will be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both. Okay, so what do you think? Is this provision still valid? Attempt to commit suicide, as in if the
No,
person is
ma'am.
unsuccessful, he will be punished. Is it still applicable?
No, no.
See what happens, right? Previously this provision was there, and whoever attempts suicide and the person is unsuccessful, right? Because if we are talking about attempt, the person should be unsuccessful. If he is successful means there is no option of punishing the person. So in case the person was unsuccessful in committing suicide, then there was this provision of punishment and the person was actually punished also. But then later on, it was realized that actually this does not make sense punishing the person. Because if somebody decides to commit suicide, means the person is already struggling with his own life. On top of it, if we are punishing the person, making him criminally liable, that will not solve his problem in any way. Okay, that is why we have this other legislation, Mental Health Act. Under that, we have this provision, Section 115, okay, which says that if somebody tries to commit suicide, court will presume, okay, court will presume that the person was under severe stress, and that's the reason why he committed suicide. So rather than punishing the person, what we will do is we will try to provide him treatment, care, rehabilitation to the person, so that he can, like, go back to his life, rather than punishing the person and just increasing the problem for him. Okay, but still this provision is here in IPC because it is not being, like, repealed or something. This provision is still there, but when is it applicable? It will be applicable if it can be proved that the person was not under severe stress, just like that he tried to commit the suicide. There, person may be punished under this provision. Okay, so as a safety option, this is kept. But in general, whenever a normal person tries to commit suicide, this section would be applicable rather than applying IPC. Have you heard of her, Iram Sharmila? There is one legislation.
No, ma'am.
There is one legislation, okay, which is called as Armed Forces Special Powers Act. Like, there is a concept called preventive detention. Preventive detention, okay. Usually, what happens? A person is arrested only when he has committed a crime or he's suspected of having committed a crime. Right? But preventive detention says that you can detain a person, you can arrest a person even before he commits a crime on the basis of suspicion, because you feel that might be this person will commit a crime. So beforehand only you arrest the person. That's nothing but preventive detention. Okay, so there is one legislation called Armed Forces Special Powers Act, which is applicable in some of the northeastern states, including Manipur. Okay, so what happens under this is armed forces are given this special power that you can detain a person if you feel like this person might commit a crime. Only on the basis of that suspicion you can arrest a person. Okay, and because this law is not, like, that effective, because you can just arrest anybody, right, and simply say that I was just suspecting he might end up committing a crime. There you might try to arrest somebody whom you do not like, just for the sake, because you have the power, right? So against this legislation, a lot of people protest as well. Okay, and she is the one who used to protest against this legislation, and I think for some 16 years she was on hunger strike. She was on hunger strike that I will not eat anything until and unless this law is removed from Manipur. It should not be applied in Manipur. Okay, so when she was on hunger strike, that is nothing but attempting suicide only, right? 16 years. If you do not eat anything, means the end is nothing but death. So what happened here is court, like, police officers arrested her multiple times also, forcefully they fed her also. So this, in this situation, section 309 would be applicable, because there is no stress as such, right? Yes, this law is not good, but if it is applicable in entire Manipur, all the people are suffering. As such, she is not suffering anything more, or that she would commit suicide, right? So she was arrested multiple times under this provision. So that's the reason why this provision is not being removed, but in general situations this only would be applicable. Okay, 150. So punishment for abatement, if we have a separate provision like this one, that would be applicable. If not, whatever is the regular punishment given for the complete offense, that punishment, same punishment would be given. There was this case wherein Supreme Court held that the explicit mens rea To do an offense is a sine qua non or very important thing for doing conviction under 107 of IPC. So we require mens rea as well. It should not happen that just like that the person was saying something, other one assumed that he's directing the person to commit a crime and he ends up committing a crime. So mens rea would also be required. Now, why are we even punishing a person who has not committed the crime directly, but who is just abetting commission of the crime? So when we talk about abatement, as we mentioned that there would be more than one person involved. One person would abet, another person would commit the crime. So when more people are involved in a crime, more criminals are involved, the possibility of them being successful also increases. Also, the severity of the crime also becomes more. And just because they are not directly being part of it, that will not help them to escape the punishment, because indirectly they have contributed in commission of the crime anyways. So that's the reason why we punish a person for abatement under principle of second degree. Okay, then there are differences between common intention and abatement. Okay, abatement, and there is one provision, common intention, that you will get. What is common intention? Maybe there are two or more than two persons who are having common intention. To fulfill that common intention, they commit a crime. Okay, so abatement is a stand-alone offense and can be punished all by itself. But having a common intention is no offense on its own and has to be read with consonance with other crimes. So when we talk about common intention, it would come along with other crimes. Okay, so the provision is section 34. Whenever you read cases, right, you will see with other provisions or with other sections, section 34 is added. As in, a certain crime is being committed by more than one person, and those people were having common intention. So, this is a very important section that is added along with other different sections wherein crimes are being specified. Okay, so abatement is in itself punishable, but common intention would come along with other sections, because as such you would not see any punishment for common intention. Okay, so it would come along with other sections defining different types of crimes or different punishments. For abatement, the accused may not be present at the crime scene. He might have abated, he might have encouraged the person today, and tomorrow the person goes and commits the crime. Okay, so but under common intention, his present is an indispensable element and he would participate whether actively or passively. It might be passively the person is participating, that would also be enough, but participation would be there. But in case of abatement, might be he has just encouraged and it is over, or might be he just supplied the gun and then he was not doing anything, right? Abatement by way of aiding the criminal. For abatement, the crime need not be committed, but for common intention, crime must be committed. After commission of crime only, we can make the person liable, because common intention as such in itself do not have a punishment of its own. So this provision has to go along with other sections only. Okay, so we discussed about three different types: by instigating, by conspiring, and by way of aiding the other person. Okay, so abatement defined under section 107, and The entire provision is contained in Chapter 5, Section 107 to 120. Abatement is nothing but to provide aid, assistance, or giving command, or to encourage the other person to commit a crime. When we talk about abatement, it can be done by way of three different ways: instigating a person, encouraging a person, and to provide aids to a person so that he is able to commit the crime. So, in all these three cases, the person can be held responsible for abatement under principle of second degree. In case we have a separate section mentioning separate punishment for abatement, that would apply. In case it is not, then the regular provision would apply. Uh, section 306 would be applicable. If otherwise separate provision is there, we would try to apply the separate provision only. We want to punish the abater because it is he has also contributed there, right? Just because he did not commit the crime with his own hands, he cannot escape the punishment altogether. And also, one person committing a crime, that is less serious. More than one person's committing a crime jointly, that is more serious, and there is more possibility that they would succeed. So it makes sense to punish the person who has abated something. Okay, common intention abatement should be different. Abatement is different from common intention because in case of common intention, it's not as such punishable on its own. It has to come along with other sections defining different types of crimes. So section 34 would always be mentioned in cases, right? Section 34 read along with. So along with there would be other sections defining crimes, but abatement is punishable in itself. Okay, is it clear?